Distinguished participants, colleagues, ladies and gentlemen, friends of truth and justice. Pursuant to customary international law and international human rights law, the right of victims to claim and receive reparation for gross violations of human rights has a solid legal basis. This was already affirmed in 1928 by the Permanent Court of International Justice in its judgment in the Chorso factory case. This is the principle known as ubi jus, ibi remedium. In his 2014 report to the General Assembly, my colleague Pablo de Greef, the first United Nations Special Rapporteur on the right to truth, justice, and reparation, emphasized the erga omnes obligation of states to make reparation as a matter of interstate concern. Erga omnes obligations are those peremptory obligations vis-a-vis the entire world, and we all have a stake in their enforcement. The progressive development of international law stipulates the right of individual victims to pursue their claims for redress and reparation before national justice mechanisms and international fora. Suffice it to mention Article 8 of the Universal Declaration of Human Rights, Article 2 of the International Covenant on Civil and Political Rights, Article 2 of the Covenant on Economic, Social, and Cultural Rights, Article 6 of the International Convention on the Elimination of Racial Discrimination, Article 14 of the Convention Against Torture, Article 39 of the Convention on the Rights of the Child. The petitions procedures of the Human Rights Committee, Committee Against Torture, Committee on the Economic, Social, and Cultural Rights, etc., allow individuals to present their complaints against states parties. Interestingly enough, Turkey is a state party to the optional protocol on the Covenant on Civil and Political Rights. In the field of international law, Article 75 of the Rome Statute of the International Criminal Court reaffirms the right of victims to, I quote, reparations, including restitution, compensation, and rehabilitation, unquote. In his 2019 report to the UN Human Rights Council, the current United Nations Rapporteur on the right to truth, justice, and reparation, Fabian Salvioli, notes, I quote, despite the existence of a strong normative framework and international and domestic jurisprudence, and the recognition by states that victims do have a right to reparation, victims do not see this right realized. Even in countries where domestic reparation programs have been set up, many challenges remain to achieve adequate, prompt, and full reparation for victims of gross human rights violations. In his recommendation, Salvioli notes that in the design and implementation of domestic reparation programs, states should ensure that such programs include different forms of reparation beyond compensation, such as measures of satisfaction, restitution, and rehabilitation. Over the years, the United Nations bodies have established pertinent jurisprudence and reaffirmed the right of victims to reparation. For instance, in General Comment 31 of the Human Rights Committee. Not only the UN treaty bodies, but also the old Commission on Human Rights and its successor organ, the Human Rights Council, have elaborated norms intended to inform national legislation and practice. Some of these declarations and resolutions have been elevated to the United Nations General Assembly for adoption, including the basic principles and guidelines on the right to a remedy and reparation for victims of gross violations of international human rights law, which were adopted by the GA by consensus in the year 2005. These basic principles are of particular relevance to Greek claims, not because they introduced new rights, but precisely because they confirmed pre-existing rights. Section 7, paragraph 10 of the Basic Principles stipulates remedies include the victim's right to equal and effective access to justice, adequate, effective, and prompt reparation for harm suffered, access to relevant information concerning violations and reparation mechanisms. Section 9, paragraph 15 stipulates reparation should be proportional to the gravity of the violations and the human harm suffered. Paragraph 16 stipulates states should endeavor to establish national programs for reparation and other assistance to victims. Tell that to the Turks. Paragraph 17 stipulates states shall enforce domestic judgments for reparation. This is actually one of the tragedies that we see in examining state party reports in the Human Rights Committee and elsewhere, where you see that there are judgments in favor of victims, but these judgments are not being implemented in the states whose courts have issued those judgments. Allow me a few words about the relevance of the Genocide Convention. Some observers have argued that the Armenians and the Greeks have no justiciable rights because there is no competent tribunal and because the Genocide Convention cannot be applied retroactively. This is a false argument, in my opinion, as a lawyer, since crimes of genocide constitute a special category of international wrongful acts and are not subject to objections ratione temporis. It should also be remembered that the Genocide Convention was drafted and adopted precisely in the light of both the Holocaust and the earlier Ottoman genocide against the Armenians, Greeks, and other Christian minorities. I explain all of that in this little book, The Genocide Against the Armenians and the Relevance of the Genocide Convention. No one would question the legitimacy of the claims of the survivors and descendants of the victims of the Holocaust simply because the Nazi atrocities were committed before its entry into force. It bears repeating that the rights of the Greeks and of the victims of the Holocaust do not derive from the Genocide Convention. Rather, the Genocide Convention strengthens the pre-existing rights of Greeks, Armenians, and Jews to recognition as victims, to restitution and compensation. Articles 144 and 230 of the Treaty of Sèvres, signed on the 10th of August 1920 by 4 representatives of the Ottoman Sultan Mehmed VI, recognized the rights of the survivors of the extermination campaigns against the Christian minorities of the empire and accepted the obligation of the Turkish state to investigate these crimes, punish the guilty, and make reparation for confiscated or destroyed property. However, the League of Nations never established an international criminal tribunal to try the Turkish perpetrators. Numerous trials under Turkish law did take place in Istanbul in 1919. Even before the Treaty of Sèvres was signed, the Turkish authorities conducted these trials against Ottoman officials involved in the genocide pursuant to the Ottoman Penal Code. Many were convicted, and I have information that 3 persons were executed, but I stand to be corrected. The Treaty of Sèvres was never implemented because of a coup d'etat. We talk about the illegitimacy of putsch and coup d'etat movements. In any event, the Sultan was overthrown by a Turkish general, Mustafa Kemal, who not only overthrew the Ottoman Empire, but proceeded to wage war against the Greeks, the British, and the French, push them out of Anatolia, and negotiate a new peace treaty with the Allies, which ensured impunity for thousands of Turkish officials, officers, and soldiers involved in the genocide. Ladies and gentlemen, I consider the Treaty of Lausanne contra bonos mores. I consider it to be contra legem. I consider it to be an aberration. I consider it to be anachronistic, completely incompatible with modern international law. It is a dinosaur. It is a juridical dinosaur that should not be in the landscape. It is a treaty as obscene as the old treaties concerning slavery and the colonial treaties, etc., which of course are caduc. They are no longer valid. What we need is a statement by the International Court of Justice in an advisory opinion saying that this treaty flies in the face of the United Nations Charter, flies in the face of the entire body of international human rights law, including the Genocide Convention. There's no doubt that the genocide against Greeks was many times worse than the ethnic cleansing that occurred in the former Yugoslavia in the 1990s, a crime which the United Nations General Assembly, in its resolution 47/121, considered a form of genocide. There's no doubt that the massacres of the Greeks were many times worse than the massacre of Srebrenica, which the International Criminal Tribunal for the former Yugoslavia and the International Court of Justice both condemned as genocide. Of course, what is of relevance today is not the punishment of the architects of the genocide, Talat Pasha and Talat Bey and Enver Pasha, and their accomplices, because no person criminally responsible for the massacres is still alive. What is crucial is the right to the ancient Greek homelands, which entails the right to return and the right to restitution and compensation. In this context, it is relevant to cite the final report of the United Nations Special Rapporteur on the human rights dimensions of population transfers on Shaukat al-Hassani. I quote, this declaration, by the way, was adopted by the Commission on Human Rights and by ECOSOC back in 1998. In Article 8, I quote, "Every person has the right to return voluntarily and in safety and dignity to their country of origin. The exercise of the right to return does not preclude the victim's right to adequate remedies, including restoration of properties of which they are deprived in connection with or as a result of population transfers, compensation for any property that cannot be restored to them, and any other reparations provided for in international law," end of quote. Let us take a brief look at natural law and general principles of law. Crimes against humanity were crimes before the British, French, and Russian note condemned the Ottoman massacres of 1915, calling them, quote, "a crime against humanity and civilization." Although the term genocide did not exist yet, the massacres already constituted international crimes before Lemkin coined the term in 1944. According to Article 38(1), little c, of the Statute of the International Court of Justice, general principles of law are a principal source of law. Among these principles we recognize ex injuria non oritur ius, which lays down the rule that out of a violation of law, no new law can emerge and no rights can be derived. This is a basic principle of justice and of common sense. Another general principle is that of the illegitimacy of unjust enrichment. That is, the thief cannot keep the fruits of the crime. Yet another principle stipulates that the law must be applied in good faith, uniformly, not selectively. In my book, The Genocide Against the Armenians and the Relevance of the Genocide Convention, I refute the Turkish contention that the Greek and Armenian rights have lapsed. Greeks today should continue pressing their demands for reparation in the form of restitution of their cultural and religious heritage, including churches and monasteries, compensation for destroyed property, as well as for the immense moral suffering endured, and a measure of satisfaction in the form of an effort at finding mass graves and the remains of the murdered relatives, an official apology from the government of Turkey, and recognition of their status as victims of genocide. What is most needed is the political will of governments to ensure that appropriate legislative and judicial measures are taken in order to implement the applicable norms of international law. For this political will to materialize, it is necessary to educate the media, journalists, and politicians. Only if the facts of the genocide become more generally known will it be possible to mobilize civil society in all countries. Non-governmental organizations like Amnesty International and Human Rights Watch should focus on the continuing effect of the genocide and insist on the need for education, rehabilitation, and reparation. Allow me to refer to the International Law Commission's principles of state responsibility, Article 31 of which stipulates the responsible state is under an obligation to make full reparation for the injury caused by the intentionally wrongful act, and injury includes any damage, whether material or moral, caused by the intentionally wrongful act of a state. Turkey cannot escape state responsibility by pretending that it is not the successor state of the Ottoman Empire. This argumentation was tried unsuccessfully by Serbia in connection with the crimes committed by the Federal Republic of Yugoslavia. There is yet another reason why this argument necessarily fails, namely that the genocidal acts of the Ottoman Empire were continued under Kemal Ataturk against the Greeks of Pontus and Smyrna, the Chaldeo-Assyrians, and other Christian minorities in the Turkish Republic. Not only were massacres committed against the Christian minorities, but there was a concerted effort to erase their memory, to efface traces of their existence in Asia Minor through thousands of years, a deliberate policy of cultural genocide characterized by the destruction of churches, cemeteries, and symbols. Priceless cultural heritage that today should be reconstructed and recognized not only as Greek, but also as UNESCO World Heritage of Mankind. It is this kind of continuous violation of international law and human rights norms that is so often ignored by the media. In a very real sense, the Turkish authorities have practiced the old Roman policy of damnatio memoriae, the destruction of the memory of the victims, as if they had never existed. Now, I refer, of course, to the Hague Convention for the Protection of Cultural Property of 1954 and its protocols, which provides additional guidance. I'll have to skip a lot of material now. As far as compensation is concerned, Article 36 of the Principles of State Responsibility stipulate the obligation of a state to compensate for the damage caused insofar as such damage is not made good by restitution. As far as satisfaction, what we call satisfaction is usually an apology. Article 37 stipulates the state responsible for an internationally wrongful act is under an obligation to give satisfaction for the injury caused by the act insofar as its obligation cannot be made good by restitution or compensation. Satisfaction may consist in an acknowledgement of the breach, an expression of regret, a formal apology, or another appropriate modality. So this, again, is contrary to the official negationist policy of Turkey. In claiming just reparation, the Greeks should also appeal to international solidarity and to the erga omnes obligation not to recognize the effects of crimes against humanity and genocide. Article 10 of the already mentioned United Nations Declaration on the Illegality of Population Transfers stipulates where acts or omissions prohibited in the present declaration are committed, the international community, also erga omnes, as a whole and individual states are under an obligation not to recognize as legal the situation created by such acts. In ongoing situations, states are obliged to ensure the immediate cessation of the act and the reversal of the harmful consequences, not to render aid, assistance, or support, financial or otherwise, to the state which has committed or is committing such an act in the maintaining or strengthening of the situation created by such an act. As to the continuing nature of the genocide and its consequences, we must remember what has already been mentioned, and I already mentioned it yesterday, the virulent Turkish racism and discrimination directed against Greeks and Greek Cypriots. Many have forgotten the atrocities committed on 6-7 September 1955, the government-organized pogrom against the Greek population of Constantinople, the infamous Setembriana, about which I published this article in the old publication of my friend Israel Charney in the publication Genocide Studies and Prevention. It's also in this big, thick book that I showed you yesterday by Dr. Sprionis. The anti-Greek animus has hardly abated. The gravest violation occurred in 1974 when Turkey illegally invaded the island of Cyprus, occupied 37% of the territory, and expelled 180,000 Greek Cypriots from the north to the south of the island. The United Nations Security Council condemned the Turkish invasion and occupation of Cyprus, demanding that Turkey withdraw its troops from the north to no avail. Unlike in the case of Iraq's illegal invasion of Kuwait in 1990, there were no consequences whatever for Turkey. In flagrant violation of Article 49 of the Fourth Geneva Convention of 1949, Turkey went on to implant more than 120,000 Turkish settlers from Anatolia in northern Cyprus, a dangerous demographic manipulation that has been condemned by many scholars. Meanwhile, the European Court of Human Rights has repeatedly condemned Turkey's violations of the European Convention on Human Rights, notably in the Loisidou against Turkey cases and in the interstate cases Cyprus and against Turkey. These cases illustrate how the genocidal animus of succeeding Turkish administrations continues, while the 2003 Titina Loisidou judgment did result in payment of 1 million euros in compensation for the lack of access to her properties in Kyrenia. There are thousands upon thousands of Greek Cypriot victims who have not received any reparation whatever. Let me conclude by saying that the Greek claims to restitution and compensation are very much valid today. The Greeks have a legitimate right to recognition of their status as victims, a right to truth, and a right to historical memory. Such recognition is a fundamental human right and a sine qua non for reconciliation. For decades, the Greeks were victims of silence. Indeed, it is a matter of fundamental justice to vindicate the memory of the victims through information and education. Today, it is urgent to break the silence surrounding the genocide against the Greeks. The Armenians have been successful in obtaining wide recognition of the genocide and of their right to reparations. In 2015, an important report on the Armenian right to reparations was made public. The same arguments contained in that report apply in the Greek context. The report's editor-in-chief, my friend Professor Henri Thierot, will join us tomorrow by Skype. I'm on the last page. It is also crucial that the Greek victims invoke all existing international and regional mechanisms, including the special procedures of the United Nations Human Rights Council and its Universal Periodic Review. The current Special Rapporteur on the Right to Truth, Justice and Reparation, Fabian Salvioli, should receive all necessary information so that he can undertake an in-depth study into the relevant issues of reparation for the Greek victims. Moreover, and this I have proposed in some of my own reports to the General Assembly, an advisory opinion of the International Court of Justice on the legal question of the consequences of the Ottoman genocides against the Armenian and Greeks is possible and necessary. I also explained the procedure, how to get there. Such an advisory opinion, of course, must examine reparative justice for the victims and refer them to appropriate United Nations mechanisms. It is time, as I said before, it is time to declare the Lausanne Treaty contrary to fundamental principles of law and justice, to reject it as contra bonos mores, as incompatible with the United Nations Charter and the whole body of international human rights law. The Treaty of Lausanne, as I said, is a juridical dinosaur, an aberration and anachronism, and it must be declared invalid. I am confident, ladies and gentlemen, that out of this very fruitful conference, a plan of action can and will emerge. The conference proceedings should be sent to the United Nations High Commissioner for Human Rights, to Michelle Bachelet, and should also be sent to the United Nations Secretary General, Antonio Guterres. I believe information is power. So everything that has been said here in these 2 and 3 days must have an impact. And in order to have an impact, it is necessary to bring this information to the hands of those who are in a position to make things change. I thank you.